Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome. I'm Alicia Downey, and today's episode of our Curious Amalgam is entitled, Who is Rahul Rao? Meet the newest Deputy Director of the FTC's Bureau of Competition. One of the great things about our Curious Amalgam is getting to know some of the fascinating people involved in the world of antitrust and consumer protection law, whether as enforcers, practitioners, or economists. Today, we'll be talking to lawyer Rahul Rao, the newest Deputy Director at the FTC's Bureau of Competition. In addition to asking him about his work at the FTC, we'll hear about his unique career path and what advice he can share with lawyers at various stages in their career journeys. My co-host today is Jeny Maier. Hi, Jeny.
Hey, Alicia. Glad to be here.
Hi, Jeny. Would you like to introduce our guest and kick off the conversation?
Absolutely. I'd be so happy. Rahul Rao joined the FTC as Deputy Director of the Bureau of Competition in September of 2022, and he is part of a front office leadership team overseeing more than 300 attorneys and professional staff enforcing the U.S. antitrust laws. Before that, from 2018 until he joined the FTC, he was a managing assistant attorney general and antitrust division team leader for the Office of the Attorney General for the state of Washington, which is a leading state enforcer of antitrust and consumer protection laws. And he also happens to be one of my law school classmates, and I am so delighted to have the chance to catch up with him here and introduce him to all of you. And so welcome to our Curious Amalgam, Rahul.
Thank you. Thank you, Jeny. Thank you, Alicia. Before we begin, let me get the obvious out of the way and say that my remarks today are my own and not those of the commission or any commissioner. It's great to be here, and not just classmates. We were section mates, so we go back to day one of law school.
Yes, I have a picture on my phone of all of us at graduation, which I looked at before coming here today, which was great. So let's start there at law school graduation. Why don't you kick us off by telling us about your career path after graduation?
Yeah, well, it's a bit of a nonlinear path. Right after graduation, I clerked for a year. I clerked on the DC Court of Appeals for the then Chief Judge Eric Washington. After my clerkship ended, I went to McDermott, Will & Emery in Washington, D.C., where I joined the trial department and originally focused on appellate matters. And part of being in the appellate group was that I just developed a skill in research and writing and critical motions practice. So I was essentially parachuted into a lot of other divisions to help on, 12B motions or summary judgment motions. And eventually kind of hit me that, making partner as an appellate associate is maybe not the easiest path all the time. I was trying to think of in terms of my longevity at the firm, what would be something that would interest me. And I transitioned into white collar and securities defense. And after a few years at McDermott, I moved up to New York and joined Morgan Lewis, where I also did litigation work and did white collar securities defense up there, including a very exciting 1-month trial with the U.S. Attorney's Office on an insider trading case. So I was in big law for, close to a decade ish. And honestly, it was exhausting. It's not an easy path, as many of the people listening to the podcast probably know. And I decided I just wanted to take a break. And so just took a little bit of a sabbatical from practice and moved out west for lifestyle reasons. And during that time, during my break from practice, had a son and decided to be a stay-at-home dad for a few years, and was thinking that, he's going to go to preschool at some point, and he's going to leave me, and what am I going to do with myself? And thinking that if I were going to leave him early, before preschool started, what would it be, and what would it be? And I looked into, and public service was something that was really meaningful to me, and that's when I decided to join the Washington State Attorney General's office in their antitrust division. Did that for 4 years and came over here to the FTC, into the front office.
All right. Well, let's unpack this a little bit.
Yeah.
Starting from your first career change, was there a particular moment or experience that, kind of led you to make the decision to leave law firm practice?
Yeah. So I am one of the small few big law expats that did not hate it. I actually really, really liked my time in a large law firm. I mean, I think the work that I did was really interesting. It was really exciting. It was at a really high level, and I worked with a lot of really great people. Really, what it came down to is, as much as I loved the work, the volume was high, especially at a New York law firm or a DC law firm, and really just wanted to take a little bit of a breather from that and regain some perspective in terms of, what I wanted. And also wanted to move out west, like I said, for lifestyle reasons. And I wasn't barred. I moved first to California, and I wasn't barred in California. So it also provided a very natural reason, an explanation to take a little bit of a sabbatical. But, one of the things that I think, Jeny, you may remember is I went to law school to be a public defender. Like that's why I went to law school. And when I was a 3L, I had 2 job offers. I had a job offer to join my clerkship and a job offer to be a public defender in Philadelphia. And I took the clerkship. And it was when I was clerking that I realized that, every case I got, I really loved. And the more complex it was, the more I loved it. And that was like the motivating force behind moving into a large law firm, because to put it glibly, big law is expensive, and people don't send their work to those law firms unless they think someone else can't handle it. So that was kind of like the thought process at the time as a young 25, 26-year-old of going to big law. But realizing after doing it for like a decade that I went to law school for public service. There was there's an intellectual component that I got out of complex commercial litigation, but there was an emotional aspect that was missing. There was a bit of a void. And that's when I realized public service is a way to scratch that itch. And antitrust specifically, it's complex commercial litigation. It's everything I loved out of big law in terms of the complexity and the scale and the scope and the quality of lawyering. It's all there. But I'm doing it for clients that I really love and really love representing. And it's not to say that I had many bad feelings about the clients I represented while at these law firms, but it was a bit more amoral. And here I feel like I'm really helping people in a way that other people can't help them, or in a way they can't help themselves.
I think a lot of lawyers who've gone from big law to public service have expressed, similar thoughts about the value of what they do. But let's roll back to the time you spent with your little son. In what way did your skills as an appellate litigator translate to being a stay-at-home dad?
Oh, what ways did it help? He is, when he was a baby, he couldn't talk, but he's a really good arguer.
Negotiator.
He's a shrewd negotiator. He can very forcefully make a point and poke holes in kind of the dictates that I put on him. But really, it's also dealing with difficult personalities as us lawyers are used to. But honestly, I don't know how much how much was transferable from being a lawyer to being a stay-at-home dad, other than I loved it. It was, the pay sucked, but it was the best 2 years, that I've spent. And I'm very happy and delighted and proud of that time I got to spend with him.
Yeah, well, a lot of lawyers who've been deeply involved in raising children will say that experience helps them as a lawyer, both with respect to not only dealing with difficult people, but also time management, right?
Yep. Time management, patience, perspective, right? It's this idea of, getting a sense of what's actually important, right? One of the things that, at least from a recruiting perspective, you notice when you recruit people, straight who went straight from college to law school and then go into, private sector, is whatever that first job is. That's the most important thing they've ever done in their life. And sometimes the people who have taken time or have gaps, have a different perspective on like what's important, are able to prioritize things a little differently. And I think getting to spend that time with my son has really given me a perspective on priorities, and being able to say yes to the things that are important, and being able to recognize and be able to say maybe not now for the things that are lower priority.
One of the things I was curious about was whether you perceive a big difference between working for, say, the Antitrust Division in a state AG's office and working in the federal government, specifically the FTC.
Well, there are differences, and I think one of the bigger differences is in state government, there's a bit more, you can move a bit more nimbly, right? And part of it is this is a difference between the FTC as an organization, which is a commission-based organization, and a much larger organization than a state AG, which is you answer to one person, you answer to the Attorney General, and he or she is typically one or two floors upstairs, and it's easy to get an answer and move quickly, as opposed to at the FTC, we need to have commission votes and things like that. So in that sense, the states are able to move just more nimbly. And I think another thing that is different is there's just a different court system. Obviously the courts are courts, but state courts tend to be a little bit more friendly to state attorneys general. And right now we have a federal bench that, in some parts might just be a little bit more hostile to the federal regulators. And so that also changes kind of the calculus in terms of, the strategy behind how you bring a case or when to bring a case. Those are some differences. But really, I think it's the nimbleness with which a state attorney general can move.
And during your tenure at the Washington State AG, your office was fairly high profile in the antitrust work that you all took on. Was there a particular case or set of issues that you had the opportunity to deal with that you are personally most proud of?
Yeah, that's actually a pretty easy one. It's the stuff. It's not just what I'm most proud of at the AG's office, but I think it's probably what I'm most proud of, in my entire career. Is I led the Washington, what we called our No Poach initiative, which was an industry-wide investigation into the use of franchise no poach provisions, and it was massive. We investigated 450, 500 companies, entered into binding agreements, court enforceable agreements with about 230-ish franchise chains, and litigated against one. And that one settled as well. And, to take a step back and just to, explain what these no poach provisions were, is they were clauses in franchise agreements, which are the agreements between a franchisor and a franchisee, that purported to restrict the mobility of employees at a franchise from going from one franchise to another franchise, or going from the franchisee to a franchisor, or some form of direction, whether it's recruiting or hiring or soliciting or something like that. And there was a research paper that came out that talked about these agreements and talked about the depressive effect that they had on wages. And so we in Washington, once again, we were able to move quickly, and we decided to just clean up this industry. And that was great for me. That was, we're talking about 235-ish franchise chains. That was over 200,000 locations nationwide. We got nationwide relief out of it as well. And that impacted millions and millions of employees. And the thing about that, and the thing about, connecting it back to this void I felt in my private practice about, helping, about the public service side of things, with someone's labor, any marginal increase that we did to increase the value of someone's labor, any marginal increase for the competition of that person's labor, whether that resulted in 10 cents more per hour or a better shift or better benefits, that was and is real value that flowed directly into the pocket of the people who need it most. We're talking about people who work fast food jobs, who are making minimum wage or less than a living wage, maybe working more than one job. And to be able to have that kind of direct and immediate impact on such a large scale, if that's the best thing I ever do, I will retire happy. like that felt great. And that kind of really hit it for me in terms of how big this void was of what I was feeling before. I don't think I fully appreciated it until I got to feel it.
Well, that work really did seem to get the conversation kicked off in Washington and around the country from the federal enforcers about labor issues in the antitrust. Is that part of your portfolio now at the FTC, or how has your job scope changed since you've joined the agency?
Well, so when I was at Washington, I did handle almost all of our labor competition efforts. So it wasn't just the no poach; it was non-competes and things like that. At the FTC, I am part of a leadership group there. I'm not the only, you guys said newest deputy director. I'm not the only deputy director. I oversee mergers 1, mergers 4, anti-competitive practices, and our healthcare division. So to answer the question, is labor part of my job now? I think labor is a part of everyone's job at the FTC, and I won't speak for DOJ. But I assume there too, right? So if we are reviewing a merger, let's say a hospital merger, which would be something to come out of mergers 4, we will be looking at the effect on labor markets, right? We're not just looking at output markets. We're going to be looking at the input markets as well, and we will make sure that a merger doesn't have a negative effect on someone's ability to earn a fair compensation, or could lead to exploiting a worker or something like that. So this is part of the review for everything. For all mergers, whether it's a high-tech merger or a hospital merger, or whether it's done in my shop or someone else's shop.
Kind of transitioning a little bit away from your current work, could you tell us about a mentor that has had an important influence on your career path or the way that you practice law?
Yes, that's a good question. So there's probably 2 people who probably had the biggest impact on charting the trajectory of the lawyer that I am today. And I think this is something I think there are younger lawyers who are listening to this podcast as well. And I think this might resonate with them, or something they should think about, because I think I lucked into it. But the people that you work with early in your career are so important to shaping the lawyer that you end up being when you air quote grow up. And that's for better or for worse. And for me, I lucked out that the 2 people that I worked with very early in my career were phenomenal and practiced law in a way that I aspired then and aspire to practice now still. The first was my judge. And the second was the first partner I worked with at McDermott. His name was Chuck Work. With my judge, obviously, the thing that I just remember most about that, or the thing that I take away now, is the beauty and elegance of writing, right? Especially as a clerk, you will notice that the vast majority of lawyers are really bad writers, right? We emphasize it a lot in law school, and the vast majority aren't great, and they do a fine job. They do a good job for their clients, right? Like, as poor a writer as you are, the law and the facts are what the law and the facts are. Which means that if you're a good writer, you have a significant, you have a competitive advantage. And if you're a great writer, you have 95% paved your way to success, right? It's that rare. And my judge really focused on the elegance and beauty and simplicity of writing, right? Especially writing to an audience where everybody understands what you're saying. And so the ability to distill complicated issues into something that the layperson understands is something that I take today. If my 6-year-old doesn't understand what I'm saying, or what, it's not something I would write. If it's not a word I would use around him, it's not a word I would typically write. And I think there's, like I said, a beauty and an elegance there. The other big influence, like I said, was that first partner I worked with, Chuck Work, and he was an older partner. He was, at that time, he was on the cusp of retiring. And so he came from an era of practice where litigation was less about gamesmanship. And it was less about, you look at some of the young younger litigators now, and I'm putting my own age bracket here when I say younger litigators, is there's almost like a sportsman-like gamesmanship to how they go about litigating, that it's about beating the other side. And for Chuck, that's obviously true. You want to win for your client, but the people you're against, the lawyers you're against, they're not your enemy. They're just a different form of colleague. And there was a professionalism there. I think for us, especially in the antitrust bar, it's just such a tight-knit community. It's so small that your credibility is your currency. And so recognizing that, hey, our clients, whether you have a private client or your client's the government or the AG or the commission, our clients may have a disagreement and our clients may have animosity, but you and I as agents, we are colleagues and professionals just of a different sort. And coming at it with that from that approach is just something that I've taken to this point in my career, and it's something that I think is a credit or I credit to why I'm able to kind of settle cases or reach resolutions. Is it's not a game to me.
Yeah, although without the crazy opposing counsel, we wouldn't have as much fun telling war stories, right?
That's true. That's true. There's the amusement factor is significantly diminished when everyone likes each other and are friends.
Right.
But it's so much nicer to be able to have a beer with one another at the spring meeting.
It is, and it's also just you never know when the person you're opposing will be your co-counsel or will be your colleague at the same firm or at the same agency. And you don't want them to think that, oh, that's the person that filed a brief and timed it so that my opposition is due on Christmas, right? Like that's not a professional way to practice, and it's completely unnecessary.
I agree. I think we've had a wonderful chance to get to know you better, but as we do with many of our guests, we like to ask you further probing questions. Specifically, we're curious to know something interesting about yourself that is outside of your professional life.
So that's a tough question to answer under best conditions, and we already talked about one of the things that was the most interesting thing about me as being a stay-at-home dad, but putting that one aside and going to maybe the second most interesting thing about me is Jeny can validate this. Anyone who's ever met me will very rightfully come to the conclusion that he is not an outdoor person, right? He thinks hiking is glorified walking, that I would rather spend time in cute coffee shops and stores than I would, around bugs and stuff like that. So that would be accurate. People would have that accurate assessment of me. So they would find it surprising, if not befuddling, that I climbed and summited Mount Kilimanjaro, which was a 7-day hike up and down this extremely large mountain, because you would not assume that if you ever met me in a workplace setting.
Okay, you're a man of many contradictions. That is interesting. The final thing we would like to do with you is play our standard game show of our Curious Amalgam. It's a little game we call The Curious Hat.
And now it's time for The Curious Hat!
The rules couldn't be simpler. Just pick a number between 1 and 12, and Jeny will read you the surprise question that corresponds with that number. We're pulling the number out of a virtual hat.
Let's go with 7.
Okay, Jeny?
Great choice, lucky number 7. So, Rahul, what is the most recent movie you've seen, and what did you think about it?
What is in a movie theater? I can answer that one. In a movie theater, I saw Top Gun Maverick, and I thought it was delightful. I thought it was exactly what I wanted out of a Top Gun sequel, and I loved it so much that I took my 6-year-olds just so I could see it again. So, yes,
Dad,
if you haven't seen Top
year.
Gun Maverick, go see it.
Okay, I like the enthusiasm. Thanks so much for being with us today. You were a great guest. To everybody listening, join us next week.
Thank you for listening to this week's episode of Our Curious Amalgam. a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.